Why don't we get started? I want to be respectful of everyone's time. I'm going to start off by introducing Kelly, our Spanish language interpreter, who will provide some information for everyone.
Good morning. My name is Kelly. I will be an English-Spanish interpreter for today's webinar. In order for you to select interpretation, I want you to go down on the bottom. You will see globe icon. You will select on that icon and you will be able to select language. In this case, you can select English or Spanish because the interpretation is going to be simultaneous, interpreted as well in Spanish. Buenos días a todos. Mi nombre es Kelly. Yo voy a ser su intérprete del día de hoy. En el computador, en la parte de abajo, pueden mirar que hay un icono de mundo o un globo. Ahí van a poder entonces dar clic y seleccionar en este caso el lenguaje al español. El webinar va a ser traducido tanto en español como en inglés. Muchas gracias. Okay, thank you.
Thank you, Kelly. This is very exciting. This is the first time I'm doing a webinar with simultaneous language translation, and I'm very excited about it. Good morning, everyone. Welcome to session 4. I
apologize, I have to interrupt. I am not enabled as an interpreter yet.
Oh,
yeah.
Let us know what you need from us, Kelly, to get that started.
Just give us a second, thank you.
Yeah, we'll give it 1 minute. Let me know when you're ready.
Is that good for you, Kelly?
No.
Oh, I just selected you. Start. You should be in there now. Are you okay, Kelly? You're welcome.
Great. Are we all set? Hearing nothing, I'm going to assume that that means yes, but please stop me and feel free to interrupt at any time, Kelly, if there's some problem with the translation. Great. I saw her message. She's ready. Thank you so much for joining us this morning. And maybe this is what I get for getting my hopes too high and sounding very excited about the Spanish language translation. That had a little hiccup to start, but welcome everybody. If we could just go back one slide, Rebecca. We are in session 4 of 5 right now. We've had 3 sessions so far for our co-op month series on a variety of issues. You find yourselves this morning in human resources best practices. I'm going to introduce myself and my co-presenter in just a second, but please stay with us. We have one more session, which even though we're getting to the end of October and I'm getting very sad about it, we will have one more on November 2nd for housing co-ops. So stay tuned for that as well. Great. I'm going to turn it over to Carolee Colter. If you wouldn't mind, just introduce yourself and I'll do the same before we get started.
Hello, everybody. I'm speaking to you from my home office in Nelson, British Columbia, in the Pacific time zone. My whole life, I've been working in one way or another for co-ops, most of them food co-ops. I've worked in worker co-ops as well as consumer co-ops. And in the 80s, I started consulting for co-ops, including most of the food co-ops in New England. I've been there in person at some point in that time. I'm now a member of Columinate, which is a co-op of consultants. And we also work with organizations that are linchpins of their communities and provide a locus of community. I conduct employee surveys. I support boards in hiring and compensating general managers. And I do troubleshooting on people problems for co-op managers.
Great. Thanks, Carolee. I am Tara Walker. I'm an attorney here in Portland, Maine at Bernstein, Shur's in the Labor and Employment Practice Group. I'm primarily a litigator. which means that I handle cases in Maine. I'm also barred in Massachusetts and Alaska. There's a story there, but we won't need to get into that today. And I represent people who are involved in discrimination or harassment claims, wage and hour issues. I also have represent a number of schools, including some co-ops among them. And I have a lot of advice and counsel. I think that's probably 50% of my work is doing advice and counsel. And especially for co-ops, I have a lot of sort of template policies and handbooks and bonus programs, things like that, that I work with a lot of co-ops in and around Maine to implement. And I'm very excited to be here today. We really wanted today's presentation to be as interactive as possible. And I realized that we're somewhat limited in the webinar format because we aren't necessarily able to see each other on video. You get to look at us, but we don't get to see you. But we do have a chat function. I would really strongly encourage you to put any questions that you have. We've left a good portion of the time today for Q&A. So unfortunately, we can't give specific legal advice, but certainly in the realm of hypotheticals, we can answer questions that you might have about specific employment laws, maybe situations that you might have questions about. We're going to run through a couple of hypotheticals and talk about some of the employment laws that we see the people we work with maybe creating nervousness or anxiety. We'll start with that, but please, whether it's in the chat or the Q&A function, just weigh in with your thoughts. This will be a really open-ended presentation today. And we rely on you for a lot of the most relevant information that we can provide to you. Anything you want to add to our agenda today, Carolee, before we turn to our first discussion topic?
No, let's go for it.
Great. All right, next slide, please. We wanted to start out today's conversation with this question, which I think prompts a lot of maybe discussion or maybe nervousness and butterflies. What employment law makes you the most nervous? And in my mind, what this sort of brings to the fore is, for clients that I work with, a lot of the issues I see is you don't know what you don't know. So I have listed out the main federal employment laws that I see people running into issues on. Hopefully some of these will ring bells for you. Fair Labor Standards Act, right? State wage and hour laws, discrimination laws that prohibit discrimination on the basis of certain protected classes like Title VII, the ADA, Equal Pay Act. I won't read through the whole list, but I encourage you to think about that for yourself. And if you want to drop one of these or more of these in the chat feature, Carolee and I will provide our own answers to this question. And if we see folks asking questions about any of these laws or responding to that question, we can certainly pick that up as well. Carolee, do you want to start and let us know what employment law makes you the most nervous?
I would say that it's the cluster of laws around ability and disability. So the Americans with Disabilities Act, which isn't just itself, but it also intersects with the Family and Medical Leave Act and or the state versions thereof, because the FMLA is only for organizations of 50 employees or more, but in a lot of states there will be laws that cover smaller employers. And then also workers' comp gets pulled in there, and a parental leave, medical leave laws. It's all very it's complex, because these laws are not written by the same legislature at the same time. They were not created to harmonize with each other. And they don't always. And so figuring out your way through that thicket can be very challenging.
Great.
What about you, Tara?
I completely agree with you. I think that when I've had to counsel clients through really difficult situations, for example, somebody who's on an extended medical leave, who also happens to have a disability, you're right. We call it the trifecta. You have state and federal FMLA laws and ADA. So I completely agree with you. I think that can be the most complex situation. And it comes up more often than people think. I know in Maine, for example, because that's where I primarily practice, it is the most common discrimination claim, disabilities. So for me, I guess the answer to that question is wage and hour laws, like the Fair Labor Standards Act. And the reason that I guess I say that makes me the most nervous, and I'm really nervous on behalf of the clients that I work with, is because this is the area where I find people don't know what they don't know. So where I see people running into trouble is the bedrock assumption. I don't know how this got started, but it's a rumor I fight every day, that salaried people are exempt from overtime. And that is not true. I am here to dispel that rumor today. Salaried people, that's one element of what is required to be exempt from overtime. But there is such a thing as salaried non-exempt employees, because the second part of that analysis that everybody I think seems to forget about, particularly because it's the most complicated, is the duties test. You have to perform certain duties in order to be exempt from overtime. And so we could get into those if people have questions about that. I don't want to dive deep down a rabbit hole for the purposes of this conversation this morning. But that the tests for what duties somebody has to perform are narrow, and they're somewhat complicated. They're not straightforward. This is just maybe a little anecdotal story. I met a woman who was primarily in charge of drafting the regulations when she worked for the Department of Labor and some of the labor and employment conferences that take place nationwide. And she shared with us that she felt like the tests were working so well because she didn't get so many questions about them. But even on her own firm's website, she's now transitioned into private practice. They don't tell you whether somebody is exempt or non-exempt. They provide a thermometer, and it's more likely to be exempt, or if it's higher on the thermometer or lower on the thermometer. I mean, the questions are myriad and they're complicated. So I've seen a number of people get dinged for having people classified as exempt from overtime requirements who do not meet that test. That test is set by law, and that's not something that you can change. So I think that's where I see people running into trouble. And even for people who are hourly paid or definitely not exempt from overtime requirements, I'm seeing a lot of confusion and issues about and I know we're going to talk about this in a little bit, about how much you're supposed to calculate overtime based on. We use the term regular rate. What's your regular rate of pay? And that can include not just your base hourly rate, but it can include certain bonuses. It can include a lot of other costs. So we're going to talk about that a little bit. But the other area where I'm seeing a lot of confusion is tips. People are more likely, especially in, say, food co-ops, you have people who are also preparing sandwiches or doing work in maybe an adjacent coffee shop and are receiving tips. Who can share in those tips? Can you create a policy where people are forced to share in those tips? Who cannot share? And how those are calculated with respect to somebody's pay. It's confusing, it's myriad, and the bad news is the costs of getting it wrong are really high. In wage and hour cases, you can get triple the unpaid overtime costs or triple damages and attorney fees. So that's the answer, long-winded answer of what employment laws make me the most.
I can think of one more thing too about the Fair Labor Standards Act, which is attending conferences or doing work off-site for non-exempt people and how they're compensated. Like if they go to a co-op conference, how you compensate a non-exempt person is really very complicated.
Oh, very good. Yeah, travel time. What is hours worked? That's not a straightforward question. Any travel time, training, those must be compensated, and people get that wrong a lot. Very good. All right. So I'm not seeing anybody weigh in. We have some shy participants this morning, which is totally fine, but why don't we jump in? We're gonna talk about some hypotheticals. We'll go through, and hopefully this will start to get people's juices flowing. Some issues that we commonly see that might help you think about, you know, do you have the right policies in place? How would you handle a situation like this? So who would like to go first? Carolee, do you want me to read this and you can take a stab at answering, or vice versa?
Well, I didn't know that I was going to be, that you expected me to answer this one. So I would, why don't you explain the challenges that are going on in here, and then I'll weigh in.
All right, let me read through the hypo first so we're all on the same page. AB Co-op is a food co-op located in Portland, Maine, coincidentally where we happen to be, with 56 employees. That will come up later on in this hypo series. Stephanie is a long-term bookkeeper for the co-op, and she's recently come to the general manager, the GM, to ask to work from home. Stephanie tells the GM she has chronic obstructive pulmonary disease, or COPD, and she's concerned about contracting COVID-19. This is a condition that I think is vulnerable to severe complications from COVID-19, so she wants to perform her tasks from home. This means the GM and other staff who work with Stephanie are going to have to start scanning time cards, invoices, accounts payable documents on a daily basis, rather than going in and being able to see her at the workplace. So what are AB Co-op's obligations, and what should the GM do? If anybody, please feel free to weigh in. If you have thoughts, or maybe what laws this might trigger, drop those into the chat. Any guesses on what obligations? What does this trigger? Give a hint, because we just talked about it. It's the laws that make Carolee very nervous. All right, seeing one response. Let me just click here. Oh, great. Oh, chat has been disabled. That's
one person's, but other people did write the ADA.
I'm seeing your Q&A, so maybe the chats are disabled. So if you can put your answers in the Q&A, that'd be great. ADA, yeah. You got it.
Yeah.
Thank you for weighing in. Reasonable accommodation. So what are the obligations? So Stephanie wants to work from home. What's the first step? What do you do when you have a reasonable accommodation? Let's assume this is a reasonable accommodation request. Is COPD a disability? What do they need to do?
Well, I think the first step is that you need to determine if this is in fact a disability. In most cases, the answer will be yes, but there are times when in my own experience with clients, where the employee has claimed something as a disability, where, well, that, the employer might want to get medical documentation, might want to say, okay, is this really true? Or could you just give me the factual documentation to show this? So that is a point, but that question, let's assume the answer is yes, and certainly COPD would, if assuming she really has it, you can get some medical records there, that would certainly count as a disability, and the risk of COVID certainly, so yeah, so it would be to allow her to work from home would be a reasonable accommodation. I do think when I look at, they'll have to scan all this stuff, there's some technological solutions that could make this easier on their end, that they could look into that. So for instance, if the bookkeeper says, if Stephanie says, so I want you to scan all this and email it to me, the employer could say, we might be able to find a better way to do that. You don't have to do it exactly the way Stephanie has said. That's what I think of looking at this, because I could see a small employer going, oh no, we have to scan and email everything instead of just dropping it off in your box. That's going to take us more time. That's going to be, that's extra labor. And the thing is, if that's what Stephanie asked for, the co-op could think of another way to approach that. You know, they don't have to do it exactly like that, but allowing her to work from home is reasonable because, you know, like, I think what are there better solutions? You can think about that. You want to have a room that nobody goes in, that nobody can go into it unless they wear masks, and you got a really good air purifier. That would be a possible outcome too, you know, a possible accommodation as well.
Very good. Nailed it. Even though I put you completely on the spot. That's exactly what I was thinking. So I would start out, typically with my clients, we would work together. Every single request is going to be different. So there's not one right answer to this, but you do need to initiate the interactive process. As soon as you become aware, and there's no magic language that somebody has to use in order to trigger a request for reasonable accommodation, she could just say, I'm not comfortable. You know, as long as you have reason to believe that this is tied to some medical condition, that will trigger an obligation to engage with that employee in the interactive process, which is exactly what you're talking about, Carolee. Evaluating what that person needs and figuring out what changes you can make on your end that are reasonable that will allow that person to continue working. So usually I start this out with putting together a certification form. I saw Susan in the Q&A had put this exactly in, and I said gold star. So typically, I mean, a lot of the questions will look the same regardless of the particular employee's situation, but I want to really caution people against the one size fits all approach. This is not a form situation. This gets individually tailored. And part of the reason for that is because the Americans with Disabilities Act restricts you from asking questions in a lot of situations, especially if the need is obvious. So a classic example the EEOC gives to this is somebody needs a wheelchair ramp, or they're physically handicapped. That's something that you can perceive and see. You don't need to go get a certification from their healthcare provider in that situation. But with Susan, right, there's a lot of questions that remain unanswered. And it's not necessarily, I'm sorry, not Susan, Stephanie. It's not up to Stephanie to necessarily articulate exactly what she needs. What she does is she takes the form, whatever you can fill out as whatever you create as a certification form, to her healthcare provider. Typically the questions on this include, you know, what is the nature of your condition, right? What are some reasonable accommodation examples? What kinds of functional limitations might you have, right? So for Stephanie, I'm going to keep doing this, mixing up Susan's excellent answer with Stephanie. Stephanie might have some physical limitations in addition to needing to perform work from home, or the vulnerability to complications from COVID-19. We don't know any of that yet. So those are the types of questions I would certainly ask. And in this particular case, I might also add in, right, what protections, like if we did need to have you in the office for any reason, what kinds of things would mitigate that risk? Masking, sanitation, right? A closed office. So I might write those questions out, ask Stephanie, give her a reasonable amount of time to sort of fill that out with her healthcare provider, unless this is something that you can just grant and allow. And then that initiates the interactive process. You'll get those answers back. And typically what my clients do is they'll sit down in a meeting with Stephanie. They'll go over the answers to those questions. They'll generate ideas. She might come up with a request. I need some equipment to be able to do my work from home. We're going to need to install a scanner. You know, this is the new process that we're going to have to go through if I'm not able to do this work from inside the building. Those might be reasonable. This is brand spanking new. After the pandemic, the historical logic on work from home has always been that that's not necessarily a reasonable accommodation. We have all seen now 2 years of mostly work from home. Most times people can do their job very effectively, depending on what their job is, from home. And so the old logic that working from home was not a reasonable accommodation is gone out the window. So maybe not that new, because we have been living in this for going on 2 years, almost 3. So it still feels very new because I have no sense of time anymore. But those are the obligations I would be thinking about. certainly. One thing I do want to also caution that I see a lot of people misusing is, well, okay, the scanning was kind of put in there as an illustration of this. What if it's an undue burden on our business or our co-op to, you know, every day we have to now scan all this stuff. We have to pick up the phone. We can't just go talk to her. I want to caution, because there is a defense to this reasonable accommodation process or a discrimination claim that Stephanie might bring if she's not granted this accommodation, that people rely on a lot. And that's that this was a burden, a financial burden on the business, or you know, just something that we couldn't complete. And that is a very, very narrow defense. You have to really show a lot of financial, it really comes down to a question of money, and you have to show a lot of financial burden, which means you're going to be opening up the books and showing that this is really a solution that we could not afford. The way that you might articulate it, if it was something you weren't able to abide, something, let's say Stephanie, instead of being a bookkeeper, let's change the hypothetical a little bit and say that she was, you know, somebody who worked in the checkout line, right? Obviously that person can't do the job from home and can't do it remotely. So that might be the way that you would respond to that, is that's not a reasonable accommodation.
I just put in the chat, I put the Job Action Network, with its URL is askjan.org. This is a fantastic resource. And it's amazing to me that the federal government produced it, when everything to do with the Fair Labor Standards Act, reading it is like trying to eat raw dough or something. To go to Ask Jan, it's like, oh, human beings wrote this for human beings. You can call them, you can do chats with them, you can do email correspondence with them, and they will help walk you through all these stages of of how to accommodate. And many accommodations have been found. Employers were surprised to find out how very inexpensive or even no cost they were, because the assumption is, oh, we're going to have to spend a huge amount of money to be able to accommodate a disabled person. That's often not true. So I would really recommend checking out Ask Jan. You could just go to the website and bookmark it for the time you might need it. And also they have many great resources you can download and human beings you can correspond with in real time.
Great. Yeah, great resource. I agree completely. I'm doing my best to try to Google translate some of the chat, but if Kelly has anything to weigh.
Oh, you know what? I wrote it just to hosts and panelists. How can I do it to I can't write in the chat to everybody as a panelist. So could someone who does have access, I can't write in the Q&A either.
Maybe I can.
Yes. But there, could someone type in askjan.org? Someone who does have access to the chat or the Q&A. And there's a question here for us. Does an employer have to purchase additional equipment for an employee's home that they wouldn't normally purchase?
Great question.
Yeah.
Yes, is the answer. So when you are engaged in the interactive process, you might have requests like this. So the interactive process means that you and the employee are trying to figure out what accommodations are going to work for them to allow them to continue working. Or in ADA parlance, we say to perform the essential functions of their job. So one of them might be different equipment. Maybe what Stephanie needs is a new computer to go in her house. She needs a scanner. That may be an obligation that the business has to provide.
Maybe she needs a better router. Maybe she needs to connect to fiber optic and have high-speed internet service, which she didn't have before. Yeah.
There are things, I mean, there are certainly costs associated with providing accommodations in a lot of circumstances. And then the way that you kind of run into limitations on that is if it reaches such a level that really there's an affordability problem, we really can't afford to be doing this, you may have an undue burden defense, but you should really talk to legal counsel, talk to a lawyer before issuing a denial on that basis, because that's such a narrow exception. I would try before getting to that exception to find alternatives if you can. Is there anything else we can do to try to address your needs? Stephanie, is that, the closed door, we're really not going to come in and see you. There should be no reason that you have any kind of in-person interaction with staff here, even if we leave papers for you, or we leave information and documents for you before going to that denial. All right. Let's see if there's any other questions. Should we move to the second?
Let's go on to the next one.
Yeah. Could you bring up the slides again, Rebecca? That'd be great.
So now you just have
play on
it. Go ahead.
Yes. This first paragraph, I'm not going to reread because that's the same, right? It's the same facts. But imagine now, second paragraph, same hypothetical, but imagine Stephanie, it's not Stephanie who has COPD herself, but rather it's her live-in mother. I'm seeing a lot more of these. I don't know if you are, Carolee. Imagine Stephanie's been experiencing serious performance problems, deficiencies since the pandemic has begun. Not answering emails, not answering phone calls, not submitting payroll in a timely manner. That's not good. The GM decides she really can't handle this anymore, and she terminates Stephanie's employment. This is kind of a loaded question, but what about, why don't we break this into a couple of different parts? What about the fact that it's Stephanie's live-in mom that has COPD that's causing her to ask to work from home?
Do you want to wait till see if we get any responses from the
audience?
audience?
Let's see.
Okay.
What do we think? I mean, so this is not Stephanie's disability anymore. She's a caretaker. Is it FMLA? Potentially. Depends on, right, whether she needs to have leave from work. That's the answer I have on FMLA. Does she actually need leave? And if so, does the mother's condition, COPD, is that a serious health condition, which is a totally different definition than what's a disability? Probably it is. My guess is that she might not necessarily need leave, but leave and remote work are two different things. So FMLA might not be.
We have a really good question here. Is she a caretaker? So FMLA.
Mm-hmm.
Yeah, FMLA is invoked here because she is taking care of a family member. Yeah. One thing I think we see, there's a lot of unanswered questions we have here, and we don't, has the GM done their homework? Because there's an interactive process here. Has it happened? Have we talked to Stephanie about what support she needs, given that she's living with this disabled mother-in-law? Like, what does she need to do the job? So we might have to, we don't know whether that's happened or not. We don't know what sort of sometimes this is what my clients, I think, really encounter that's so challenging for them, is when it appears to them that there's a it appears to the manager there's a performance problem, might be related to a disability, might be.
Very good.
And the manager opens the door to the employee to tell them that's why they're having this performance problem, but the employee won't say anything about it, doesn't bring up the possible disability. What does the employer do then? They suspect there's a disability, but they can't get the employee to talk about it.
Very good. I've seen that before too. That's a tough situation. And so you can't force anyone. You can't force them to request an accommodation. And that's a really tough one. If somebody doesn't request accommodations or doesn't bring it up, that's a hard one to navigate. I think you sort of do your best What I have seen folks do before in that situation that I think has been done successfully is issue a written warning, let's say for the performance issues, and say, if you need a reasonable accommodation, not only come and talk to me, but we will remove this discipline from your file. If it turns out that it's exactly the case and you need an accommodation from us, we will eliminate this discipline from your file. I've seen that work well for people in the past. Coming back to our example, I certainly drafted this very carefully to bring up something that I think a lot of people are not understanding and is an evolving doctrine, but is coming up a lot in the context of responding to the pandemic and COVID-19. And that is associational discrimination. Most people have as a gut instinct, if it's not Stephanie who has the disability, then I'm off the hook. And in one aspect, that's true. And in one aspect, it's not true. You do not have to accommodate someone for a disability of somebody else that lives in their home or because of their association with somebody who has a disability. So remote work, maybe they would not have to accommodate. There's no requirement that you engage in the interactive process there. But you do have non-discrimination requirements. So that's why we drafted this to include that she's terminated. Because I would say too, if ABC Co-op called me right before engaging in this termination and said, what should we do? Are we at risk here? I would say, yes, you are at risk because Stephanie may contend that the timing of this occurred, her termination is occurring right after she mentioned that she has a mom living with her who has COPD. And discrimination law doesn't just necessarily apply to the person who's has the disability or who is a member of a protected class. There's also a prohibition against discriminating against someone for their association with somebody who has a disability. This has come up a few times in a very similar context for my clients who are dealing with people who, and honestly, this really, in my opinion, tends to come up more when you have people who sense that they may be terminated for completely unrelated reasons, like Stephanie. If they're sensing that this may be, disciplinary, maybe the GM is considering putting Stephanie on some kind of performance improvement plan and issuing her discipline related to her performance issues. She may bring this up. Hey, this is also what I have going on at the time. And you want to navigate that very carefully. You want to make sure that you're not taking adverse employment action that could be, right, termination. You're not taking a step to terminate someone that could be construed as discriminatory. What does that mean? Can she still be counseled? Can she still have a performance, have performance discipline? Absolutely. But you separate those two out. Maybe you separate them.
Missing payroll is pretty serious.
That's a pretty bad one. That also creates liability for you. Missing payroll for sure. Good. All right. I'm just poking through the chat. Okay. Let's keep moving, shall we? All right. I'll read this one out and maybe Carolee, you want to take a stab at going through the first answer? AB Co-op wants to recognize the valuable contributions of all its employees having worked through the COVID-19 pandemic, and especially because of recent staffing shortages. Their team's been working very hard. To that end, it has created quarterly profit sharing bonus program in which employees share in a bonus pool in direct proportion to the number of hours that they worked in the previous quarter. What are the potential pitfalls of a bonus plan like this? And what might be best practices for AB Co-op?
I want to say that, like a lot of worker co-ops in particular, but I've seen this with consumer co-ops as well, are very drawn to the egalitarian nature of basing bonuses based on hours worked. I say a more common corporate approach to this is to base the payroll, base the bonus on the percentage of payroll that each person gets. So that means the higher paid people get more. Well, that isn't how most worker co-ops like to proceed. So that's why this particular methodology for calculating a bonus is attractive. But there is a risk with this because of the Fair Labor Standards Act. This has happened. Several clients of mine got audited by Wages and Hours Division of the Department of Labor. That's the government agency that investigates possible violations of the Fair Labor Standards Act. And what happened is Wages and Hours wasn't just out there looking around, randomly selected AB co-op for an audit. What sometimes happens is a disgruntled worker calls to Wages and Hours at very common. They want to say, I'm being paid on salary, but I shouldn't be. I'm not getting my overtime. That's not fair, or something like that. Wages and Hours, this is what happened to several of my co-op clients. Wages and Hours came and did an audit. They found that the employee's allegation was not factually true, but they found a problem with this because the co-op was doing bonuses based on hours worked, and there was something they were failing to do.
That's very classic Wage and Hour Division, in my opinion. I see this a lot. You'll get a complaint about one thing, but let's talk about the 6 or 7 other things that are very complicated. Nobody really understood and nobody complained about, and we'll ding you for those.
Yeah. Well, this one, the pitfall is that if any compensation is based on the hours that an employee works, then that compensation must be considered along with their regular hours in calculating overtime, because overtime is time and a half the regular rate of pay. And regular rate of pay is, let's say, if you're being paid $15 an hour, then let's say you're being paid $16 an hour, then when you're being paid overtime, that would be $24 an hour, right? 16 plus 8. But for the bonus based on hours worked, that has to be factored into the base. So instead, let's say that bonus got paid out as $3 an hour per hour's work for the quarter, you have to add that $3 to the 16 that the employer was making and calculate the overtime on 19, not on 16. This can be worked with. This is just a math problem. What you do is when you pay out the bonus, everyone who worked overtime during that quarter, their bonus is going to be larger than the people who didn't work overtime, because they will be getting, their bonus will be like, if it's $3 an hour for that's being paid out for the bonus, it'll be $4.50 for the overtime hours for the employees who worked overtime. It all can be given out in one check. There's just an extra step of bookkeeping there. And sometimes I have people go, oh, that's too complicated. I can't handle that. We won't do it that way. No, you can do it. It's a math problem. You can work it out, but you have to be sure to do it.
Absolutely. That's great. That's a very, very good. This comes back to the complications, right? For people who either are classifying employees incorrectly. In other words, they're saying they're exempt from overtime. And let's say somebody who gets this bonus is a salaried employee. You have a salary plus the exemption amount. I'm sorry, the overtime amount. And I see a really good question in the chat or the Q&A. I'm going to call both, but Alexandra says, would this still be true if it was an annual patronage dividend based on hours as opposed to a quarterly bonus? And my answer to that is yes, it's still true. The only difference is, if I'm understanding what that dividend is, the exception to what kinds of bonuses are included in the regular rate of pay is if that bonus is discretionary. And I would say most times probably, right, with the same egalitarian mindset, with what, you know, the philosophy and the values that co-ops have, you're not going to have a purely discretionary bonus. And discretionary means just that. It has to be something completely at the whim of, you know, the manager or the employer. So,
and it was in the worker co-op I worked in, it was in the bylaws. It was not discretionary.
Not discretionary. So, and even if it's something that you just created, that doesn't mean it's discretionary. If it's something that is tied to production, to hours, to whatever measure you have, that just isn't, I feel like I'm going to pay this particular worker this much. That's kind of the difference. I don't want to get too in the weeds, but discretionary means there's no program, there's no metric by which you're measuring someone's entitlement to the bonus, which really ties into that second question in this hypothetical. What are the best practices? In my mind, this is usually you need to have something in writing. Not usually, you should have something in writing that spells out who's entitled to this bonus, how you're going to calculate it. And typically an area where I've seen I've actually litigated a couple of cases, is what happens if somebody's no longer employed come bonus time.
You need to have provisions in writing for when people have left. Like if this only applies to people who are currently employed, you got to put that in writing.
Remember what we said, why I think Fair Labor Standards Act is the law that makes me the most nervous. You have a lot of exposure to the potential for damages, penalties, for claims that are made under this law. So I actually handled a case just before the pandemic where there was a bonus program like this. It was not in writing. The employee did all of the work to be entitled to the bonus, and it wasn't a huge amount of money that they were entitled to, but it was something. And they resigned, they quit about 2 months before the bonuses were issued. So of course the employer only awards the bonuses to the employees, portions that pool of money among the employees who are still employed there. If your bonus policy or your bonus program doesn't specify that it's only for people who are currently working, that former employee has a good claim. They've done all the things to be entitled to a bonus program. And the reason why I'm so nervous about it is because not only do they now get the unpaid bonus amount, but if they succeed in court, they're going to get 3 times that unpaid sum and attorney fees. So that's where we see a lot of claims coming, because the attorneys know they're going to get paid for these.
The moral of the story is you should have a written plan and run it by your attorney. I'd like to answer Alexandra's next question, which is, could you argue it's a profit distribution and not a bonus for performance? As long as it's based on the number of hours people worked, it's still got to be part of the regular rate of pay. I've had some food co-ops that one of their benefits is employee discount on purchases on food. And some employees have larger families than others and shop more. And so some people get a much bigger benefit than others when a percentage discount. So every now and then I have some clients say, well, maybe we should base it on the number of hours they work. And I go, no, you don't want to do that, because once you start basing compensation, this benefit based on the hours worked, you're going to have to quantify that, there's that risk of it being considered part of the regular rate of pay. But in the case of the profit distribution, as long as it's based on hours worked, you do have to consider it part of the regular rate of pay. It doesn't matter whether we call it performance bonus, profit sharing, gain sharing, annual distribution, whatever. As long as that's the formula for distributing it, you have to consider time and a half for the people who've worked overtime during the period, whether it's a year or a quarter.
Yeah, it depends. So I would say this depends, because there are bona fide profit sharing plans that are also exempt, just like discretionary bonuses. But without knowing more about that particular program, it's hard to say whether it falls within. The bonus is not the key word here. And I guess this is helpful for people to understand more broadly. It's not whether it's a bonus or not a bonus, but it does need to fall within one of those delineated exceptions to the regular rate. Other areas where I see people tripping over this is things like callback pay, right? If you can't fill all your shifts and you pay people a little bit extra to show up and fill in, when they're not on the schedule, you need to include that in the regular rate. So I want to just maybe kind of divorce us from the idea that it's the bonus that's subject to the regular rate calculation. It's everything, unless it's a delineated exception. A bona fide profit sharing plan will fall into one of those exceptions. A discretionary bonus likewise will fall into one of those exceptions, but you need to very carefully review the regulations around those and make sure that your plan meets those exemption statuses. I'm looking at the time. We've got one more hypothetical. Do we have any more questions? I just want to make sure we get a chance to go through all these. Oh, somebody else has one more question. I'll read this out. I was expecting this hypothetical to go is whether a bonus program could be argued to be discriminatory. Very good. I actually thought of this too. Is this a discrimination? Because let's say we have Stephanie, who's maybe not able to work as many hours because she's vulnerable to COVID. Or, can you be subject to a discrimination claim based on a bonus program solely based on hours worked? Possibly is my answer to that. That's a really good issue spot. We wanted to talk about Fair Labor Standards Act, which is why we went in that direction. But, purely for hours worked, if it's not necessary, let's say Stephanie is granted the option to work remotely, and she's also given the opportunity to share in the bonus and is able to work her regular schedule, that doesn't seem to me to be discriminatory in any way, just because they happen to be performing work in different locations. But what about employees who are on leave, on medical leave? So it's possible that you might want to create certain provisions in your bonus program or bonus policy to account for people to be able to participate in those who are maybe not working as many hours because of a protected medical reason. But if it's based on purely on hours worked, you've made accommodations for those things. It strikes me as a very difficult claim that just hours worked only is a discriminatory bonus program, but really good issue spotting. All right, should we do the last one? Stephanie's been working from home for some time now. She calls the GM and says she needs a break from her work as she's going to have surgery to input a lung valve implant, and that's going to take place in 2 months. Stephanie also reports to the GM she's really nervous about this surgery. She's had past trauma from a surgery when she experienced severe medical complications. She's been seeing a therapist to treat anxiety and PTSD based on those experiences, but she just can't work until that surgery is completed. So she's going to request leave, and if all goes well, she should be back to work in 4 months. So what issues do we have for AB Co-op? What about the fact that she can't meet payroll and now we don't even have a bookkeeper for 4 months? Can AB Co-op hire a replacement? What about what should we do when she's ready to return, and what are the best practices? Any of those questions you want to lead off with, Carolee?
Well, I'll say that of all the positions that are requesting this leave, a bookkeeper is probably the easiest to find. An independent contractor who can step in and do it for 4 months. Much easier than if they were somebody who was working in, let's say, a customer facing position, or some like operational kind of thing.
Or if it's GM, yeah.
Yes, yeah, so, right. Yeah. So of all the positions, this one, there's probably you have the best chance of finding a readily workable, accommodation out there in the marketplace. But So, but yes, they could find somebody to temporarily do the job, because many people do bookkeeping on that kind of basis. If it were the kind of position that it was like integral to operations on the site, and you hired somebody temporarily for it, I could see that that might be more challenging than finding somebody to do it on, a long-term basis. But in today's labor market, where everything's so much more fluid, I think that might still be easier to do than it might have been in the past, finding people that would just want a 4-month gig. In a way, like all the things that's like, I think what the management's going to have to be really careful of is not to, she's shared a lot of private stuff here. This really can't get out to the rest of the staff, because there's a lot of stigma still attached to mental health issues. And it's just not, like, you want to be very sure. The laws do require a confidentiality on the part of the manager. And what can be hard here is if other employees go, how come she gets to do this and I don't? Well, and you can't say, well, she's got, she has this disability, that's why we're letting her do it. You're not supposed to say that. So that's that I can see being one of the challenges. But to find Steph there, I would say this is a case where there's a risk that she's not going to return to work. That could happen. It does sometimes happen that after people take a leave, what they realize on the leave is, I can't handle this job. This job is making me sick. Or this is too stressful for me. I can't go back there. I can't do that. And so your temporary arrangement, it would be good if you had some fluidity with that, so that you could check back in, see whether Stephanie actually does want to come back to work, and then you're covered while you're doing hiring. I'm looking at this more from the employer point of view than like the legal point of view. So Tara, do you have something you want to say about that?
Yeah, very good. Because I really want to be respectful of everybody's time, I'm going to fly through my issue spotting and recommendations for AB Co-op in this circumstance. And then there's one question in the chat. What do we need to look out for in 2023? I'm going to address as quickly as I can, and then try to, I'm available for a little bit of time. I have about 5 minutes and I have to run to another meeting. If people have questions, I'll be happy to sort of stay behind and answer any questions that I can. For AB Co-op, this is another complicated question. If you do not already know about this, I would recommend that you Google the Wage and Hour Division FMLA certification forms. Somebody had put in the chat, do they have a medical leave policy? And I'm going to answer and say it doesn't matter. And I'm partially taking for granted that I'm very familiar with the hypothetical facts because I wrote them. They have 56 employees. And just exactly as Carolee said, that triggers FMLA obligations as long as they're within a 75-mile radius. And we'll assume that Stephanie has been working for more than 12 months. She's entitled to FMLA, most likely. First step, just like ADA, there actually are forms for FMLA. So that you want to go on the Wage and Hour Division website and download those forms, give one to Stephanie, have her fill it out. She's going to request FMLA leave. If she's qualified based on her answers to those questions, then AB Co-op will need to not only provide her the leave up to 12 weeks, but they'll also need to preserve her position. So that's why that was in there. What do we do without a bookkeeper for 4 months? An independent contractor, luckily, because Stephanie is a bookkeeper, is a really good solution to this because they can depart at any time when Stephanie's ready to return and you don't have that interruption. This can be really challenging for people. We might have to reassign Stephanie's duties while she's out on protected leave because she has the right to come back, depending on the situation, depending on entitlement to leave. But I just want to flag that issue. She could have the right to return to work after the completion of her leave. And best practices for AB Co-op in this situation, right? follow the process, follow those forms very carefully. PTSD and anxiety may be a serious health condition. It depends. That form is going to give you a lot of information that you will need to determine, and it's got information in there about how you assess whether this is something that's a serious health condition. And then let's see. Oh, I'm seeing a lot of things come up in the chat, so I'm just gonna see any. So 2023, looking ahead, there's a couple of things that have been happening in the Department of Labor that I've got my eye on recently, and this is last year, but tips changed in how you calculate tip policies. If you have back of house employees who can engage, they can participate potentially in a tip pool. You want to check your state law on this, because Maine is one of those states that even though the federal law has changed, they are not changing. They're only keeping tips for people who customarily and regularly receive tips. So for example, if it's a coffee house or something, you're talking about the baristas, but you're not necessarily talking about people who work in a roastery, for example. In 2023, they are working on redefining the independent contractor standard. So if you are somebody who does work and pays people who may arguably be employees or maybe independent contractors, that's another area of potential Fair Labor Standards Act liability. And the Department of Labor is proposing a new rule around independent contractors and changing the definition. So keep an eye out for that. I don't recall, it should be coming out soon. I don't think we've seen the proposed rule yet, but don't quote me on that because I haven't looked. Anything else? I haven't seen, there's been a lot changing in the labor context if you happen to be a unionized employer, but I don't think we should get into that because I suspect that's not going to apply to many of you. Good. I
see there's a questioner says how much for part-time or overtime. I saw that question showed up in Spanish earlier, and maybe that since the question is out of its context, I'm not sure how to answer that.
Part-time people, you have minimum wage for regardless whether it's part-time or full-time. You want to check your local, you check in a lot of places because you can have state applicable overtime, the federal overtime, which is very low, and local, sometimes ordinances for what your minimum.
You mean the federal minimum wage?
Minimum
wage
overtime?
Is very low. Yeah. And states sometimes have laws that overtime kicks in at 8 hours in a day. Several states have that.
Yes, that's true.
Yeah.
So you want to check those for part-time people. You're not going to run into overtime very often unless they're working, a few days a week, but over that 8 hours, and you happen to be in California or one of those states where overtime is required.
But if you're working part-time and in your state, it's the federal laws in effect, overtime doesn't kick in until 40 hours in a week.
So probably not going to kick in. And overtime rates are typically 1.5 times your regular rate. Yeah. But again, check your state law, because sometimes if you have too many hours in one day or too many hours in 1 week, like California, it can be higher depending. So just check. Thank you all. I know that we're now at 12:05. I appreciate you all sticking around with us through this whole webinar. If you need to, I think in our previous slide or our next slide, we have contact information for Carolee and myself if there are follow-up questions. I know I would be happy to respond to those, and I'm sure Carolee as well.
All right. Thank you, everybody. Thanks for the great questions.
Thanks so much.